Hello, everyone. I think that we've got at least, well, quite a number of the participants. Welcome to the third Farrar's Building webinar. The other two are available on our website. For those of you who don't know who I am, my name's Freddie Lyon. I called in 2012 and I practiced for 7 years primarily within personal injury and clinical negligence. Over the last 3 years, my practice has taken on more of an international dimension. I've started doing more and more cross-jurisdictional claims, hence the reason for this talk. The talk obviously comes at a time of fairly significant flux for the travel industry. This is primarily directed at not those claims that you will be seeing at the moment, predominantly related to refunds and various types of cancellations. But those claims that you may subsequently see in 6 months, a year's time, which are those claims, both from the claimant angle and from the angle of defending them, for potentially catching COVID-19 while abroad. So I'm going to share my screen and we'll start, make a start. As I say, it is a time of flux. The European Commission released a report relatively recently showing that they estimate a revenue loss at European level of 50% for hotels and restaurants. Obviously, that will vary between country to country. I imagine for the UK, it may be significantly higher than that. 85% for tour operators and 90% revenue loss for cruises and airlines. As I say, at the moment, we're dealing with a large number of refunds, but that's got to be seen in the context of already having the Air Travel Trust Fund, the ATOL fund, near exhausted as a result of the Thomas Cook bailout and as a result of the Monarch Airlines bailout before that. The ABI, so dealing again with insurers, that estimates there should be £275 million in claims related to the pandemic. That is significantly higher than the previous record, which was 62 million in respect of, I'm going to attempt it, Eyjafjallajökull, which is the Icelandic volcano disaster, which grounded so many flights that time ago, if anyone remembers that. So in that context, the last thing that the industry needs really at the moment is a significant number of claims coming in for catching of COVID-19. So that leads us on to the next question, and this sort of deals with the first half of the talk. Will travel be able to resume? Are these claims going to become an issue, essentially? Now, there has been some fairly significant movement on this fairly recently, and we're seeing more and more in the news every day about this. I have to say this talk was actually written slightly before some of these announcements have come about. And so some of these are even now out of date, even though it was only written a few days ago. So on the 15th of April 2020, the European Commission issued the Joint European Roadmap, and that is a sort of overlying document. It doesn't apply to the UK within the transition period, but it is a relevant consideration as to how the EC is going to approach these issues. Obviously, for those of you who haven't had the pleasure of reading that document, and indeed the further documents which will come on to the guidelines, this sets out in broad strokes what the EC thinks is necessary for free movement to be reintroduced on the continent between borders. We've then seen some movement from individual countries, which has been largely reported in the news, and then some countries looking at bilateral agreements, sometimes known as air bridges, sometimes known as bubbles. They're all really the same thing. These are agreements between countries to allow quarantine-free travel between them. And I've set out some examples there. The Baltic states have a bubble: Latvia, Lithuania, Estonia. Austria has proposed a bubble with Germany, the Czech Republic, Slovakia, Hungary, Switzerland, and Liechtenstein. Cyprus has proposed a bubble with Germany, Greece, Israel, and Malta. You will, of course, know, given the way the news has been going recently, that we are currently being excluded from the vast majority of those bubbles, with Spain and Greece particularly coming out recently to confirm that we will not be in the initial air bridge that they set up. That is, and of course, France as well. That is consistent, although a political decision, consistent with the joint European roadmap, which allows there to be derogation on the basis of the epidemiological position of each country. Now, of course, that is variable depending on testing and the like, but what we're looking at essentially is those countries having a reason to be able to derogate as they have. There's also a clear interest from companies, and I've set out a few examples there, which may in fact now be out of date in respect of Jet2. Almost all operators have confirmed that they intend to resume some level of service by July. EasyJet has confirmed up to 70% of service they intend to resume by the end of August. So these are companies that are making a fairly significant effort to reopen travel. Now, in respect of that's sort of the European position, but in respect of the English position, obviously we've got the quarantine that's been proposed starting next week, next Monday, which will be a 14-day mandatory quarantine for all returning people, save for exceptions which are permitted under the withdrawal agreement from the Channel Islands, the Isle of Man, and the Republic of Ireland. This is certainly coming in for a significant amount of criticism in the news today, particularly, but actually within the Daily Mail, within the Times and the Independent for now a couple of weeks, really. As I say, the European roadmap is specific that it doesn't apply to the UK, but free movement and those principles surrounding free movement does apply to the UK. I set out within the slide really where those principles come from. So you've got the Treaty for the Functioning of the European Union, which says that free movement must be extended to workers, citizens and residents. So that is including those who are not citizens but are resident within a member state country, and indeed in the UK during the withdrawal agreement period. But there are exceptions that can be made where justified on the grounds of public policy, public security and public health. And it's that word justified which is so important here. We're going to have reasons to exclude, including putting somebody in quarantine. At the moment, the quarantine is pretty well blanket. But if we want to construct any kind of air bridge, we're going to have a reason why that is with one country and not another. That's then further set out within the Free Movement Directive, that we can derogate from free movement principles where we're combating a disease with epidemic potential. Clearly, that is what COVID-19 is. And we cannot be discriminatory in the way that we lift these. The European Commission has confirmed within the roadmap that they will intervene to request the lifting of measures which are considered to be disproportionate. It is likely, given they specifically mention blanket quarantines, that a blanket quarantine will be considered to be disproportionate. But so will a discriminatory air bridge, and that in fact would be probably, if anything, more problematic for the EU than a blanket quarantine. It's very hard to guess exactly what's going to happen here. the roadmap sets out the criteria, epidemiological, so dealing with are infections at a sufficiently low level, is the R rate approximately similar, the health system capacity, again, we saw those problems in Italy particularly, we haven't seen them so much here, but again, their rate at the moment is lower than ours. It's arguable that we're not quite on the same epidemiological level, although healthcare capacity we have at the moment. And the monitoring capacity, and obviously you've heard so much about testing from the daily briefings over the last few months. That is going to be an important comparative factor as between countries. I do note there that infringement proceedings were brought in May, earlier on 14th, against the UK in relation to freedom of movement breaches. Now that actually relates primarily to what were regarded as discriminatory breaches to do with the welfare system, that certain European citizens were not entitled to the welfare system as quickly as they should be under the Free Movement Directive. And so it's not directly relevant, but what I would suggest is that shows that the Commission is going to be very, very carefully monitoring any attempts to limit borders, although they realised that derogation was going to be necessary back in March. They are slowly moving out of that and will be very, very carefully watching to make sure that any lifting is not discriminatory. Booking a holiday has obviously been specifically mentioned within the daily briefing. We're seeing stories today coming out in relation to air bridges. So far, getting out my crystal ball, it would appear to me likely that there is going to be sufficient international pressure and pressure from the companies themselves and their lobby groups, that there will be a degree of travel within the next couple of months that will be quarantineless, certainly. With that in mind, there is going to be travel while effectively COVID-19 remains a real risk. And that may be the case actually for some time. So these cases could arise. Which brings me on to my next point. This is the first slide dealing with potential causes of action. Essentially within this talk, I'm going to look at three primary causes of action, all relating to the special regimes governing foreign travel. So this slide, although it's set out as negligence, really is looking at breach of contract under the package travel regulations. I'm going to look at breach under the Athens Convention in relation to cruise ships particularly, and potential breach in the Montreal Convention in relation to airlines. In relation to negligence generally, there aren't any intimated cases that I'm aware of, and doubtless if anyone does know of any, please write it within the questions box. I should have mentioned at the start actually, I will answer questions at the end from the questions box, so please feel free to fill it out. There are no intimated cases that I'm aware of within England and Wales. However, there have been some in relation to PPE within the health service and the provision of PPE, and that's really an employer's liability issue. And to that, I'd refer you to an excellent article on our website by James Plant. There's also been a case announced within the last week, which relates to a dentist, a Dr. Talati, who is suing the Department of Health in relation to their advice at the outset of the outbreak, which he says led to him infecting his parents with COVID-19. I would have to say that I don't particularly fancy his chances at that stage of the outbreak, but we shall see. In other jurisdictions, there have been some claims already. You may be aware of the group action taken by the Austrian Consumer Protection Association. These are largely German claimants, although there are some English claimants involved. It's a fairly large group action against the ski resort of Ischgl. and that is for failing to close the resort when they were aware of a bar which had a member of staff, I believe, who was also a British member of staff, who infected multiple persons, described as a super spreader event, and was responsible for quite a degree of the outbreak. So far, that group action is limited to those who caught it at the bar, as opposed to those who later spread it to others. It's going to be interesting to see how that develops, but obviously it is a different jurisprudential system in Austria. In terms of where the duty lies, there is almost certainly a duty in respect of customers, in respect of taking proper procedures to minimize the risk of infection. Any breach of that duty is going to be based much the same way as we see already in gastro claims in relation to breach of the guidance. This is causation, remoteness, etc. apart, and we'll deal with that later on in this talk. But dealing purely with breach, there are going to be guidelines that are relevant. There are going to be potential breaches of those guidelines, and there will be a duty owed to the holiday makers themselves, in my opinion. Now, obviously, as I say, within package regs, that will be not negligence per se, but those cases always have a strong negligence flavour to them. In terms of what kind of guidelines we're looking at, well, the European Commission, again, have released the snappily named Guidance for the Progressive Resumption of Tourism Services and for Health Protocols in Hospitality Establishments. These are non-binding. They are very detailed, though. And I would suggest that they're going to be very similar to the HACCP for food hygiene in terms of the weight that judges are willing to attach to them. National bodies are also producing their own guidance, and doubtless we will have some soon, very shortly. Slovenia have recently produced their own guidance, which roughly mirrors the resumption guidance for tourism services. I don't think that they're going to be sufficiently binding to amount to what I've described there as uniform international regulations. You are going to still need to provide evidence of local standards if you're a claimant, and if you're a defendant, you're going to be well within your rights to jump up and down about this. It's not going to be the same as a gastro claim. What you're producing is not a good. It's very unlikely that these infections are spread by the ingestion of food, for example, or even from water. So for that reason, you're going to have to prove a breach of the local standard. And the reason I've mentioned specifically Wilson and Best Travel there is because of the excitement, to some extent, within certain circles anyway, around the case, which I'm going to really struggle to pronounce. Palaio Kraus and Tiescu and Black and Green Trading. This is an unreported decision of Master Thornett, which was a case relating to an air crash in Ethiopia. In that case, it was established that pilot error was responsible for the crash, and subsequently judgment was entered in default. The defendant attempted to set aside that judgment, and it was successfully argued by the claimant that the way that a pilot flies an aircraft is universal, and there are universal standards. There was no need to provide the evidence of local standard, and that did not provide a real prospect of successfully defending the claim. And Master Thornett agreed with that analysis. And so there's been a sort of a resumption in interest in the Uniform International Regulations, albeit that case was quite recent, only on the 7th of April 2020. This is not going to be that. This is going to be much more nebulous. You are going to need to have evidence of local standards in these cases. But this guidance does provide an example of the kind of thing that we're looking at. You can see there some of the analysis from it. It's a 22-page document with a very detailed annex, which goes into specifics of exactly what the EC expect from a hospitality establishment. The guidance requires there to be a preparedness plan to be produced, so effectively a risk assessment, staff training, including infection prevention and control, which previously we would only really seen in healthcare establishments. Information to guests on expected behaviours, targeted efforts to enforce physical distancing, and this is of course things like the markings on the floor, things such as you'll see efforts to minimise infection risks, so wearing masks for staff particularly, but possibly also for holidaymakers in certain situations, glass and plastic panels for members of staff as well, and of course a full cleaning and disinfection policy. Now, certainly I would advise those representing defendants to absolutely ensure that their clients, before they're running any kind of holiday or organising any kind of holiday, particularly if that holiday is going to fall under the package regs, to ensure that they are conducting full audits of all of their suppliers in the EC, and indeed elsewhere when further guidance is developed for other countries, to ensure there is compliance with these, because if they've not done that and there is a breach, that is going to be something that a court will give heavy weight to when considering what's to be done about it. Now, moving on to the second special regime, the Athens Convention. Now, these are cases dealing with the international carriage of persons on cruise ships. You'll see there, Article 3, this is the primary article under it. The carrier shall be liable for the damage suffered as a result of the death or personal injury to a passenger, so not a crew member, if the incident which caused the damage so suffered occurred in the course of the carriage and was due to the fault or neglect of the carrier or his servants or agents. So, and Article 14, I include that to show that it's an exclusive jurisdiction clause. Any of you who practice fairly regularly in these cross-jurisdictional areas will of course be fully aware of the convention. It's important to remember that it's not a strict liability system under the convention. You have to prove the fault or neglect as the claimant. There are some limited exceptions in a few specified circumstances. And the reason I've dealt with the Athens Convention specifically in this talk is because, of course, there has been extensive coverage of a large number of coronavirus infections on board ships. As at the time of writing, there were 50 ships confirmed to have COVID-19 infections at some point. There's a class action that's been brought in the US District Court in Miami against Costa Cruises. I'm trying to look up the name of the ship. It is the Costa Luminosa. Now that set sail on the 5th of March, but it's alleged that there were COVID infections on board when it set sail, that it was allowed to put into port, that it was allowed to then continue again on its voyage, potentially infecting further people, and that's what the group action relates to. It was, of course, very, very early in the outbreak, and that may go to looking at the fault or neglect, but that is something that's going to have to be seen, and we obviously don't know the outcome of that case as yet. There's very limited guidance to date. The EC again have produced a small amount of guidance, but that primarily is dealing with repatriation at this stage. There is some guidance stating that there's got to be distancing requirements. Ports should consider dedicated lanes for separate entry and exit to ensure that distancing. For short voyages, as many passengers in open spaces as possible. The cleaning and disinfection of vessels, and various requirements in relation to PPE. So how likely do I think that claims will be made under the Athens Convention? Well, one, there already are being claims made under the Athens Convention, not in our jurisdiction. But two, we do see claims fairly regularly, well, not that regularly, but intermittently for things like norovirus. There's no reason why coronavirus should be significantly different, save for potential problems on causation, which I will deal with. This is a case, Swift and Fred Olsen cruises, dealing with the norovirus case. It was fairly well publicized at the time, being one of very few norovirus cases, I think possibly the only one that has gone to the Court of Appeal. I've set out the facts there. The passengers caught norovirus on board a cruise run by the defendant. There'd been a previous outbreak on board a previous sailing, but the ship was not quarantined and or adequately disinfected in the meantime, or at least this is what was alleged. The defendant did have, in that case, a comprehensive plan as to what to do in the event of an outbreak, and that plan was compliant with industry standards. But the judge at first instance found that the plan had not been adequately implemented and that there was a causal link between the failure and the subsequent outbreak. Now, the Court of Appeal was quite careful to, while upholding the judge's finding, ensure that there was no suggestion that the burden had shifted or that anything was lessening the burden on the claimant. And you'll see there the quote from Lord Justice Gross: "Self-evidently, the taking of reasonable precautions to safeguard the health and safety of passengers is a matter of the first importance for cruise operators. To my mind, it's equally plain that unrealistically high standards cannot and should not be set." And what I've suggested there is there were some parallels with the case of Dawkins and Carnival. You may be aware of that case. It involves a slip, again, on board a cruise ship. Again, this is brought under the Athens Convention. It was a slip in the buffet area of the cruise ship. Food was on the floor. The judge, at first instance upheld in the Court of Appeal, found that essentially a Warden Tesco principle should be applied, and that there was a presumption, therefore, that the defendant needed to do something to rebut. Now, it was an unusual case because, of course, there are those presumptions within the Athens Convention, but they relate to a very, very specific set of circumstances. And the paragraph that I put there at 17, that's actually a paragraph from Swift and Fred Olsen, which shows that in the case of norovirus, the Court of Appeal thought this was different. That is the quote from the first instance judgment, which was being referred to with approval. Something more than the mere fact or extent of an outbreak would be required to raise an inference of fault or neglect or breach of contract. So it's got to be more than an outbreak of COVID-19 on board, but what they will be looking for is, have there been compliance with those guidelines, and then can there be a causative link established? And as I say, I'll deal with causation altogether towards the end. There is no reversal of the burden in a case like this, in my opinion. I can't see how it would be any different from a norovirus case, and you'll see there the case of Nolan and TUI, which I've set out at the bottom. In that case, it was suggested that one of the specific exemptions where the incident is caused by a defect in the ship should apply, and therefore the burden would be reversed. But the court in that case was very clear that that burden, that part of the convention is not engaged in the case of a norovirus infection, and that a norovirus infection is not a defect in the ship per se. I can't see how it would be any different with coronavirus. It's interesting to note that in both Dawkins and Swift, the defendant failed to put up witnesses who actually implemented the plan. And I think this would be the biggest thing that, firstly, I would look for as a claimant, but that I would also be very wary of as a defendant. If you can't get the information from those who are actually implementing the plan, you may find yourself in big trouble in these cases, notwithstanding that you have a very, very comprehensive plan. And so it's something to be extremely, extremely wary of. And that was quite short, so we'll move on to the Montreal Convention. The reason I'm taking slightly longer on the Montreal Convention is because I think certainly that this is the biggest risk for defendants and potentially the biggest element of claimants because of the almost strict liability principles in Article 17.1. Obviously, that strict liability is only up to a certain level, but many of these cases will not be, if they happen, will not be high value. The convention currently is about 128,000 odd SDRs, special drawing rights, which equates to around £150,000. Most of these cases will be below that. Above that level, the principles of negligence start to be relevant, but below that, we're looking at Article 17.1. The carrier is liable for damage sustained in case of death or bodily injury of a passenger. Again, note passenger, not crew member, or person, as the convention would have it, upon condition only that the accident, and we'll look at that, which caused the death or injury took place on board the aircraft or in the course of any of the operation of embarking or disembarking. So there are a number of hurdles that are going to need to be overcome. The claimant is going to need to establish that COVID-19 is a bodily injury for the purpose of the convention. They're going to need to establish that effectively contracting it was an accident. And that is one of the biggest questions, which, having looked, nobody else has put their mind to quite yet. And then causationally, it's going to need to have happened on board or in the course of embarking or disembarking. That is going to be exceptionally challenging. But there are clearly cases where this is potentially liable to be spread on airlines. And I've quoted that academic article at the top. That was a case study of a flight from Hong Kong to Beijing during the SARS pandemic. At that time, a 72-year-old man boarded in Hong Kong. He was a doctor. He'd recently visited a sick relative, his niece, and he was ill when he boarded. He managed to infect 21 people from his seat, including some 7 rows away. And he also infected 2 stewardesses who had traced themselves to 300 infections in Mongolia. Again, SARS is obviously a coronavirus. It's not COVID-19, but it is sufficiently similar that one can imagine that spread of that type would be possible on an aircraft if, certainly if full precautions were not taken. There's been a recent news article on the 31st of May where it was announced that a flight from Germany to China had been taken with 1 passenger testing negative when getting on in Germany, but positive for COVID-19 when getting off in China. We don't know yet whether there will be a number of infections from that flight or indeed whether any claims will arise. It is notable that no claims that I have been able to trace arose during the SARS epidemic, but that was a much, much smaller epidemic in comparison to what we're looking at now. So dealing with the first hurdle, is COVID-19 a bodily injury? I can answer this one fairly swiftly, I think. I think it probably will be. And the reason I say that is the House of Lords decision in King and Bristow Helicopters, which was a conjoined appeal with Morris and KLM Royal Dutch Airlines. Now, these quotes from Lord Hobhouse that I've set out here aren't obiter, but it does clearly show that the catching of a pathogen could be a bodily injury. And certainly we've seen cases for food poisoning and the like on board aircraft. There is no reason, I would suggest, why catching an airborne pathogen of this type could be any different if it subsequently results in you having a fairly severe disease. Lord Hobhouse sets out there that there is potentially a seriousness component. This hasn't really been tested very much in relation to the disease. A cold not being bodily injury, AIDS, hepatitis being a bodily injury. COVID-19 is difficult with that because, of course, it affects people very differently. For some, and the vast majority, it is a mild disease, but for some, it is very, very serious. I would suggest that certainly in the case where it was anything more than almost asymptomatic, it would be sufficient to be a bodily injury on that test. Certainly we see cases potentially with people talking about permanent damage and the like. There is some problem in relation to how common it is. Now, obviously, at the moment, we're dealing with something that's effectively endemic, but that will not remain the same. As infections come down, it will become less and less common to catch COVID-19, and it will therefore be more and more unusual for the purposes of the test. That brings me on to my next point, which is whether or not it's an accident. Now, barring causation, this is the biggest challenge in any of the COVID-19 cases for claimants. And you'll see there, I've quoted from Saxon Air France. Now, this was under the Warsaw-Hague Convention, but it's been applied to quite a number of Montreal Convention cases since. So the accident must be an unexpected event or happening that's external to the passenger, says the US Supreme Court. And I've set out there's some examples of accidents. So assault by a fellow passenger. And I think that's quite interesting because obviously that's not necessarily related to the operation of the flight itself. In Morris and KLM, this was Miss Morris was a 15-year-old girl who was sexually assaulted by the person sitting next to her. Now, whether or not a passenger infecting you accidentally or deliberately would constitute an accident is a difficult question. Again, I set out the other examples. It must be established the event's external. Well, it's going to be external to you, I suspect, catching the disease, if you can prove that it was caught on board or in embarking or disembarking. It's going to have to be shown that you caught, that you actually caught the disease at that time as part of the convention. But it's not necessary for you to show symptoms on the flight. It's likely that the catching of the disease would be sufficient for that purpose to be an event. Now, one of the things that is said there in Sachs, it's an unexpected event. Now, that's unexpected from the perspective of the passenger. Again, at the moment, it may not be that unexpected to catch COVID-19. It's sufficiently endemic in the community. But as that becomes rarer, that will change. And it is likely that there will come a point where it is sufficiently unexpected. There is one further issue as well, which is ICAO and has just recently, and the World Health Organization recently worked on a series of regulations for aircraft. They're in fact so recent that they're not included within this talk. But under those regulations, there is some irony because, of course, the more regulation that one sees in relation to this, the more and more a breach of those regulations, a causative breach, or indeed something happening despite those regulations, is liable to be seen as an accident. And that is something that we're going to have to wrestle with from both sides of the fence, probably within these coming months. It's got to be more than just that. In fact, that you just caught it on board the aircraft. It's got to be an unexpected happening. And there I set out the case of Ford and Malaysian Airlines. That is a difficult case about the injection of a diuretic on board to a passenger who had previously suffered from cystitis. It turned out that the diuretic should not have been given and actually caused her further problems. But the Court of Appeal said that the injection could have happened anywhere. There was nothing unexpected about it. The fact that the doctor, who was also a passenger, was unable to have access to all of the diagnostic tools, etc., did not render it an unusual state of affairs or unexpected, and that accordingly it was not an accident for the purposes of the definition in the convention. As I say, this is a whistle-stop tour of this issue, but this is going to be a big issue in any of these claims, and will require very, very careful analysis, both of the epidemiological position globally and between the countries, the international countries the flight took place, but also a very, very careful legal analysis, and it's likely to go to appeal when one of these cases comes to court, I think. Very briefly, there is a defence of contrib under the Montreal Convention under Article 20. It recognises 100% contrib in certain circumstances. I can't see a 100% contrib circumstance in a COVID-19 case, but there may be things like a failure to wear a mask or similar that could be, if these are measures instituted by the airline or advised by the airline, could be sufficient to mount a contrib defence, and it's something certainly that defendants will need to keep in mind if these claims come in. So, remoteness and proximity. These are issues about who you actually owe the duty to, really, in my opinion. This is obviously quite challenging legally, but it appears to me that it is unlikely that you are going to, as a defendant, tour operator, airline, cruise operator, to owe a duty to anyone more than, in respect of COVID-19, to anyone more than your passengers or holiday makers, those with whom you have the contract or have rights under the contract. There are sections in the convention that allow for wider claims, but it's my opinion that there will be a public policy decision made at some stage that will limit these claims, because otherwise, of course, you are effectively liable to the entire world if you spread an infection. It is certainly foreseeable that a holidaymaker returning infected would infect their family and could infect people around them, particularly with a disease as infectious as this. But I don't think that's going to be sufficient to enable the proximity to be properly established. Causation, and this is the big one, the major stumbling block, I think, in any of these claims. This isn't gastric illness, it's not norovirus. The incubation period is much longer and it's uncertain. We don't know yet really what that incubation is, save that it is between 2 and 14 days. Now that's compared to a very, very, very defined incubation period of 1 to 2 days for norovirus, 1 to 5 days most salmonella, 2 to 5 days for Campylobacter. Now these are obviously the most common things we see in gastro claims. It doesn't mean that it's impossible. There will be those times where you are able to pinpoint that infection. And that will change as the virus becomes better understood. As the virus becomes better understood and becomes more localized, I think you would be very short-sighted to think that causation will pose as much of a difficulty as it will at the moment. Cases that are occurring around now will be very, very, very difficult on causation. But there are cases already that we're seeing with the increase in testing and the increase in monitoring where infections are able to be pinpointed. I've certainly read about an outbreak being pinpointed to a single unwashed salt shaker in a German case. If it's possible to pinpoint to that degree of accuracy, and there will obviously be disputes between experts on this, it may well be possible to pinpoint, notwithstanding the incubation period, to a hotel or to a particular passenger on a ship or on a plane. If that's the case, obviously on a plane, for example, there will be particular concerns, but if one considers a disabled passenger, say, who is kept separate from everyone else, boards without everyone else, is taken through the airport without everyone else, and then is taken off the plane at a separate time due to having to wait for a wheelchair or whatever, that is going to be quite easy to pinpoint to the flight itself. Causation may not prove as big a hurdle in those cases as we would think, but it will provide a very significant limiting factor on these cases and mean that it is really only a few that are going to be able to get through. It's certainly not going to be a new gastro illness type claim. We're certainly not going to see loads and loads of these. I'm running out of time, so I'll include this very briefly. There may be contribution claims against holidaymakers. We've seen one already in Jeju Island in South Korea. This was widely reported. It's my opinion that when you're dealing with these sort of things, you're dealing with effectively public health awareness and potentially awareness for holidaymakers in general. It's not something that we're going to see on a regular basis. It's not something that we're going to see having any particular effect unless this particular passenger has enormously deep pockets. I wouldn't see it as a revenue stream, but it is something that's worth considering in those few cases if you need to send a message or there's been particularly egregious behaviour that you want to raise attention to. Finally, it's not all doom and gloom. It does look like there are going to be, from a claimant perspective, some cases coming out of these. From the defendant perspective, it doesn't look, in my opinion, like there's going to be loads and loads of them, but they may provide some fodder for lawyers, and it does look as if we're going to be getting back into some degree of travelling within the next couple of months. And hopefully we're all going to get back to working normally soon when the courts begin going through their backlog. That's my talk. Let's see if there are any questions. So I've got a question here from an anonymous attendee about, do you think that cruise companies may potentially be exposed to corporate manslaughter charges following COVID-19 deaths on board cruise ships? That is an exceptionally difficult question. I would be reluctant to commit myself to saying that there will be. I would suggest that it is certainly possible in certain circumstances, but I would need to look very much more carefully at it to be sure one way or the other. It will depend on the facts, obviously, and it would have to be a very, very, very egregious failure that would result in charges. At the start of this outbreak, I think it is very, very unlikely that we are going to see any charges due to the novel nature of the disease, due to the reaction of governments. It's only going to be in those very, very rare cases where there was clear advice, where that advice was clearly breached, and where it resulted in deaths. And I haven't heard any reported cases that would fit that. But we'll wait and see. I could be wrong about that, and we may well see some in the future. Are there any further questions? Doesn't look like it. That was very easy. If anyone does have any questions, then please feel free to email Chambers. I'd be very happy to answer them at any stage. And hopefully I will get to see you all soon in person. It's looking like a long way off, but let's hope it happens soon. Anyway, very nice to talk to you today, and hopefully see you soon.